This is case number 24, CR113, State of Ohio versus Roger Allen Filmore. Attorney on behalf of the state is Assistant Prosecutor Kane. Attorney on behalf of the defendant is Attorney Catherine Hapner. And you're Roger Allen Filmore?
I am, sir.
All right, Mr. Filmore is charged with illegal conveyance, trafficking, and cocaine, and possession of cocaine. The matter was set for a plea hearing this morning. I believe the matter may be set for trial the 12th or the 14th of November. I have a plea of guilty form here, Mr. Filmore, which is 3 pages in length. Has your name, case number on it. Indicates you're going to plead guilty to count 1 on the first page. On page 3, there's a line that reads, "I enter this plea voluntarily." Immediately below that appears to be the signature of Roger Filmore. Is this your signature I'm looking at?
Yes, sir, it is.
When did you sign this document, Mr. Filmore?
Monday.
All right. When you signed it, did you understand it was an agreement to plead guilty, which means there won't be a trial? The next step in your case would be a sentencing.
I do, sir.
And did you go over this with your attorney and have her explain it and answer any questions you might have before you signed it?
Yes, sir.
Do you feel that you had enough time to fully consider the matter?
Yes, sir.
Since you've had a couple of days to think about it, have you made had any regrets or decided that you didn't want to do this?
No, sir.
You're still going forward with this?
Yes, sir.
You're doing that voluntarily?
Yes, sir.
All right. Page 1 indicates you're going to withdraw your not guilty plea. Plead guilty to count 1, illegal conveyance of weapons of prohibited items onto the grounds of a detention facility or institution in violation of section 2921.36A2 of the Ohio Revised Code, a third-degree felony. States that you understand that the maximum penalty for that could be a range of between 9 and 36 months imprisonment in the increments provided by law, a fine of $10,000. You understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
Non-reporting probation.
What court is that in? Municipal court?
Yes.
Okay, but that's a misdemeanor.
Yes.
Okay. Now, under the law, in the event that you are sentenced to prison for this offense, upon completion of the sentence, it is possible the Adult Parole Authority may, under the law, put you under what's called post-release control supervision excuse me, for a period of up to 2 years. If they do, you'll be supervised by a parole officer in the terms they set. And if the parole authority determines during that period of time that you have not complied with their terms, they have the authority to return you to prison as a sanction or penalty for that violation for a period of up to 9 months for one violation, but there is a cap or limit of half of whatever the prison term was for all violations. However, in the event that you are convicted of a new felony while under post-release control, then in addition to whatever sentence the judge in the new case can impose upon you, that judge can also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence in the new case. You understand that?
Yes, sir, I do.
Now, under the law, Mr. Filmore, I'm not required to sentence you to a term of imprisonment for this offense. I can impose what's called community control or probation, and that means that instead of going to prison, you would be supervised by a probation officer under the term set by the court for a period of up to 5 years. If during that period of time probation felt that you were not complying, they would file a written notice of that with the court and give you a copy. There would be a hearing. You'd be entitled to be represented by counsel at that hearing, and in the event that the outcome of the hearing was you had failed to comply, then at that time the court could revoke your community control and then sentence you to 36 months and fine you $10,000. And if your community control is revoked in part or whole because you had been convicted of a new felony while under community control, and you received a prison term for that new felony, the terms of imprisonment for that case and this case could be ordered to be served consecutively or one after the other. Do you understand that?
I do, Your Honor.
Right now, the charge in count 1 reads that on or about July 6, 2024 in Highland County, Ohio, you did knowingly convey or attempt to convey onto the grounds of a detention facility, I'm not going to read the other part, doesn't apply, to wit, Greenfield Jail, a drug of abuse as defined in section 3719.011 of the revised code, in violation of section 2921.36A2. So that's the charge in the first count with the penalties I just described. Mr. Filmore, do you understand what it is you're charged with in that count, what the state said you did, when, where, and how they alleged you did it?
I do, Your Honor.
Do you understand the possible penalties for that offense?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of the trial with the attorney?
I have.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Has anyone threatened you to make you plead guilty today?
No, sir.
Now, on page 2, there are a couple of lines printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to count 1. State will dismiss remaining counts. State and defense will argue sentencing, and a pre-sentence report is requested. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty?
No, sir.
So you've not been told that if you plead guilty, you're going to get any particular sentence?
They offered 18 months, and then we countered offered it.
Well, what I'm saying is, though,
yes.
You in this agreement as you
Yes.
are pleading, if you plead guilty, you don't expect to get any particular sentence?
No, sir.
Okay, so you understand that
Yes, sir.
everything from community control to 36 months is on the table?
Correct.
And $10,000?
Yes, sir.
Right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
I do not, sir.
Excuse me. All right. You have certain constitutional rights, which I understand, Mr. Filmore, before I can accept your plea. First, you have a right to have counsel, and Ms. Hapner was appointed to represent you in this matter. Now, that appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that the law permits. And so if you decide you do not want to plead guilty, but you would want to defend against the case, that she'll continue to represent you and defend you, including a trial, if that is what you want. Do you understand that?
I do, Your Honor.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be chosen from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 people are selected, the evidence would be presented. They would be instructed on the law. And then that jury of 12 would have to decide by unanimous verdict, meaning all 12 of them would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. And in that case, you will have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it will be the judge. Here's the evidence. The judge applies the law, and the judge decides whether or not the state proves your guilt. Do you understand that?
I do, Your Honor.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that may be present. After the prosecutor's done asking those witnesses questions, your attorney can ask questions. That's called cross-examination, and the purpose of that would be to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses that you feel you want to have testify that are not going to come in voluntarily, at your request, the court will issue a subpoena, which is a court order. And that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here. And that's the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
I do, Your Honor.
Now, under the Constitution and the laws of the state, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever force you to testify. The judge can't, the prosecutor can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings, and no one's even allowed to talk about it except in one situation. If you have a jury trial and do not testify, the judge does instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
I do, Your Honor.
Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged, but proof beyond a reasonable doubt. So what that means is that the burden of proof isn't on you to try to prove you're not guilty because you've been indicted. In fact, under the law, you don't have to present any evidence at all at your trial to defend yourself. You can, but you're not required to. But whether you do or not, the burden of proof remains upon the state of Ohio to prove your guilt on every essential element of this offense by proof beyond a reasonable doubt. And that's the highest burden of proof that is known under the law. Do you understand that?
I do.
Now, originally you entered a plea of not guilty, Mr. Filmore, which denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I have just described this morning. If you change your plea from not guilty to guilty on count one, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in count one, admit that it's a crime, and that you committed the crime. And that plea waives and gives up all the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. It would waive or give up your right to confront the witnesses against you and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're the one that's saying you're guilty and that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances, you could file an appeal. That appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
I do, sir.
And are you a U.S. citizen, Mr. Filmore?
Yes, sir, I am.
Now, you have any questions about the charge or the possible penalty?
No, sir.
You understand?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
Have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir, I do.
Have any questions about the plea of guilty, what it means, and what the consequences of that will be if you enter it here today?
No, sir.
You understand?
Yes, sir.
Is there anything you need to speak to Ms. Hapner about before we go any further?
No, sir.
Have any questions at all about anything I've explained here today?
No, sir.
Then, Mr. Filmore, is it your decision to voluntarily withdraw your not guilty plea to count one and enter a plea of guilty thereto pursuant to the terms of the plea agreement we've just gone over?
It is, sir.
Right? Then, as to the charge in count one, which alleges that, and I'm going to only read the pertinent part, that on or about July 6, 2024 in Highland County, Ohio, you did knowingly convey or attempt to convey out to the grounds of a detention facility, to wit, the Greenfield Jail, a drug of abuse as defined in section 3719.011 of the revised code, in violation of section 2921.36A2 of the Ohio revised code, the charge of illegal conveyance of weapons or prohibited items onto the grounds of a detention facility or institution, a third-degree felony, carrying a possible prison term between 9 and 36 months, a fine of $10,000. How do you plead?
Guilty, Your Honor.
All right, thank you. You can be seated. The court finds on this day in open court the defendant was informed of all of his constitutional rights and made a knowing, intelligent, voluntary waiver of those pursuant to Criminal 11. Plea of guilty to count one is accepted and ordered filed. Defense found guilty. Pursuant to that plea, counts 2 and 3 are dismissed. Court will refer the matter to the probation department for pre-sentence investigation. Shall include an assessment for substance use disorder treatment and or mental health assessment. Sentencing will be on December the 3rd at 1:30 p.m. and bond will be continued. I do have a note from the jail that you have not reported there for processing on this case. As soon as we get done, you get your assignment notice. Go to the probation department to report to them to schedule your pre-sentence investigation appointment, and then report to the jail and tell them you need to be booked. They need to photograph you, fingerprint you, DNA, and all that stuff.
They already did that, Your Honor.
Well,
Just check with them. and make
it's
sure.
just do it.
Okay.
Because they sent me the record, said that they never.
They had to take
What
one
about
to
that?
the jail. And
Oh,
process
well,
the relationship.
Just check to make sure.
Okay.
It's easier to check to make sure you got it.
Yeah.
Ben said you had him,
There's land up.
had him qualified.
Okay, where is it?
To my brother's house.
And so you'll go to the probation department first.
It was a different case.
Okay,
I'll just tell you.
Okay.
All right, so, like I said, it says that you didn't, it's signed by the administrator, said you didn't, it may be it was on a different case, I don't know, misdemeanor case or something, but anyway, you'll need to be reported down there to Mr. Arjima for that purpose.
Okay,
And then to the jail to be booked.
okay.
All right, get your assignment notice here from the bailiff, then report down probation, and then to the jail.
Okay. Thank you, Your Honor.
Thank you.
That December 3rd.
Okay. At 1:30.
All right, this is case number 24, CR 109, State of Ohio versus, is it Jai?
Yes, sir.
Jai Kessinger. Present on behalf of the state is Assistant Prosecuting Attorney Adam King. Present on behalf of the defendant is Attorney Captain Hatton. Mr. Kessinger has identified himself. The defendant has entered a plea of guilty to aggravated possession of methamphetamine, a third-degree felony in violation of Section 2925.11 of the Ohio Revised Code. The court ordered a pre-sentence investigation. I did receive that, and I have reviewed that. Have each of the attorneys had an opportunity to review a summary?
State has one.
I have, Your Honor.
All right, Mr. King, anything on behalf of the state?
Only what is contained in the plea agreement, Your Honor.
All right, Ms. Hatton,
Thank you, Your Honor. May I approach?
you may.
Your Honor, my client did complete residential treatment at Eubanks. I thought we got it just
Okay.
straight. He completed that towards the end of last year, and then this year he's been involved with Brightview. So he's been involved with the Brightview.
Oh, Brightview?
Yeah, I do have those records too, if the court would like to look those.
Okay. All right, I have an additional statement from the Recovery Council.
Okay, yeah, and that was where he was referred to, I think, by Tanya. So he has been taking steps. He's been confronting his addiction, recognizing, and I think that's a big step, is recognizing that there is a problem, there is an issue. And addressing that, I believe that he is a good candidate for community control, that he's been reporting as required on his pre-sentence reporting, and so we ask that you follow the agreement, the plea agreement, and I'm sure if you have any questions for Mr. Kessinger, he'd be more than happy to answer those.
Yes, ma'am.
All right, Mr. Kessinger, is there anything you would like to say?
Yes, Your Honor. I've worked really hard to stay clean. I've been clean for a year and just over 3 months. It's been hard, but I'm pretty much over everything, and I've done really good.
Okay, thank you. Well, I will say that one of the things that is important for the court in terms of determining whether somebody's sincere enough is that the efforts they make to help themselves without being forced to do so. And so what you just said, I think, is indicative of that, is that you've been sober for over a year and you did seek treatment and you've maintained it. One statement I will disagree with you on it, and that is you say you think you're just about over it. You're never going to be over it.
Oh, yes, yes.
Sobriety, is a journey, not a destination. People get to a point of sobriety and then they say, okay, I'm good. Well, you're not, because the addiction is something that's physical, it's organic, and it is always lurking there. And so you have to be very vigilant and always remember, that every day that you do it, it makes it, I think, I've never been through that journey, but from what I observe, it appears to make it more likely you're going to continue to stay sober. But there's always the risk of relapse, and you have to be extremely focused on that and aware of that, and to avoid the triggers, avoid the situations that might cause you to use. Because what we see is that in many cases, relapse is almost like an involuntary physical reaction when there's a stimulus, somebody such as meeting an old friend and they hold out a joint and say, you want to light one up. And they just automatically do it, don't even think about it, because they've done it for years and years and years, and it's almost like the body says, oh yeah. And so you have to be vigilant. So that's one thing I want to say is, don't be overconfident.
Yes,
you
sir.
have to focus on this every day for the rest of your life. The longer it goes, the easier it'll be, and that will become your involuntary physical reaction. But you've done a great job so far,
Thank
but
you, sir.
you need to be aware. So I just wanted to point that out.
Thank
now,
you.
it's the order of the court then that you be sentenced to a term of community control of 3 years under the supervision of the probation department. You're to comply with these conditions. You must obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements you make to the probation department regarding your supervision. You must keep them informed of your residence, place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. I don't know if you have to do that on your work or not, but if you do, you have to get a written pass from your probation officer and have it with you at all times.
Yes, sir.
And that even includes, of course, right now we've got the bridges under restriction, but if you go to Cincinnati and take 471 across the river and come back, if you were to get stopped in Kentucky without a pass, you'd be in violation of the interstate compact. So,
Okay.
always make sure you do that. You're not to enter upon the grounds of any correctional facility, nor may you communicate with anyone who's an inmate in those facilities without written permission of your supervising officer. Now, because of your conviction, you're disqualified and not permitted under both federal and state law to purchase, possess, own, use, or have under your control any firearm, ammunition, or dangerous ordnance. And if you were to do so, you could be subject to being prosecuted under both federal and state law for a felony. That's also a condition that you not have any of those or any other types of weapons while you're under community control in this case. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has effects similar to those. Nor may you possess any instrument, device, or thing that may be used to administer or prepare drugs for administration unless you have a lawful prescription. You must have it not only for the substance, the drug, but also for the device. And you're to provide a copy of that to your supervised officer. You're to submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any kind of an alcoholic beverage. Nor may you be present in places where they're sold or being consumed, even if it's otherwise lawful. You're not to associate with anyone who might be a co-defendant in this case, or any other person who has a criminal record as a member of a gang, or any criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless that is approved in writing by your supervising officer. And that would include any family members that may fall within that definition, unless you were working or living with them immediately before the commission of the offense. You must report, you may not, after the date of this order, marry or establish cohabitation in a new relationship, common law type of relationship with another without written permission. You must report any contact with law enforcement or an arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You'll provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for an evaluation assessment for any kind of treatment, therapy, counseling, training, or other programming beyond that ordered by the court, you'll submit to that. If the evaluation or assessment recommends treatment or programming, you're to enroll in and follow that and complete that successfully. You're to pay the court costs of this action and make payment arrangements to do that. And then you'll also comply with any treatment recommended by recovery counsel, aftercare, whatever they may recommend.
Yes, sir.
Now, by being placed on community control, rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, or vehicles that are owned by you or used by you, or any other property or place that's under your control where you're found at any time by any officer of the probation department. You'll be required to sign a written acknowledgement and consent to that at the probation department. There will be no fine, there will be no driving suspension imposed. You're ordered to pay the court costs, which is a substantive order, and if you don't do that, as well as a condition, if you don't do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets. Also could have referred to collections, which could include then an additional 30% to be paid to the collection agency. And if that doesn't collect it, then the court could order you to do community service in this county and give you credit for each hour you worked and an hourly rate set by the court. Each hour you worked would reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you are not complying with the conditions, they will file a written notice that with the court and give you a copy. There will be a hearing. You'll be entitled to have an attorney at that hearing. If the outcome of the hearing is that you have failed to comply, then at that time the court could revoke your community control and sentence you to prison for between 9 and 36 months in the increments provided by law, fine you $10,000. And if you are revoked because in part or in whole for a felony committed while under community control, and you receive a prison term for that offense, those terms in this case and in that case could be ordered to be served consecutively to one another. Now, in the event that occurs, upon completion of the prison term, the law provides that the adult parole authority may exercise the option to put you under post-release controlled supervision for a period of up to 2 years. If they do, you'll be supervised by a parole officer on the terms they set, and if during that period they determine that you have failed to comply, they can return you to prison as a sanction and make you serve an additional period of up to 9 months for any one violation, up to a maximum of half your prison term for all violations. However, if you should commit a new felony while under post-release control, then in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, or whatever time is left on the period of post-release control, whichever is greater. And if that occurs, that would be required to be served by law consecutively to the sentence in this case. All right, is there anything further, counsel?
No, Your Honor.
All right, well, that completes your case, Mr. Kessinger. You're no longer under pretrial supervision. You'll be under the new conditions I've just explained. You need to report down to the probation office to arrange for that transfer to the felony supervision officer.
All right.
Thank
Thank you, Your Honor.
All right, this is case number 23 CR 111, State of Ohio versus Amy M. Rickman. Representing the state is Assistant Prosecuting Attorney King. Representing the defendant is Attorney Sarah Barger. And you are Amy M. Rickman?
Yes, sir.
All right, Ms. Rickman entered a plea of guilty to aggravated trafficking in methamphetamine, a fourth-degree felony. The court referred the matter for a pre-sentence report. I have received and reviewed that. Have each of the attorneys had the opportunity to review a summary?
State has, Your Honor.
Yes, Your Honor.
All right. Mr. King, anything on behalf of the state?
Only what is contained in the plea agreement, Your Honor, and the restitution to the task force in this case is $40.
40?
40, yes, that's all.
Ms. Barger?
Thank you, Your Honor. I will say this about Ms. Rickman. We would like you to follow what's in the plea agreement. However, Ms. Rickman has done a total turnaround in the short time that I've known her. The first time that I spoke with her, she was, I don't want to say combative, but slightly argumentative and didn't seem like she wanted to chat, is the best way to put it. Since then, we've had multiple conversations. Her demeanor has completely changed since she's gotten into treatment. She's currently at Stepping Stones. She's doing quite well. The person that I'm seeing today is a 180 from the person that I met at her first hearing and have had multiple conversations with. We asked that the court give her the opportunity to continue her treatment and on this path of progress.
All right, Ms. Rickman, is there anything you'd like to say?
No, Your Honor.
All right, I see, I do have the report from Counseling Center that you entered there on the 22nd. Okay. I also have a report that you, on the you went to the Jalissa's house at the Recovery Council on October 15th, tested positive for several substances. Next day refused to take a test. Next day tested positive for meth and amphetamine, and on the 18th for marijuana, and then left on October the 19th with another client, and you didn't return. So, the fact that you did go to the counseling center is the reason I'm going to go ahead and grant you community control, because what you were demonstrating previously was an unwillingness to acknowledge your problem, and probably was going to require you to spend some time, maybe even a substantial length of time behind bars. But because you've done that, it is the court that you be granted community control and are sentenced to a period of 3 years of community control under the supervision of the probation department under these conditions. You're to obey all laws of all jurisdictions, conduct yourself in all body, manner, at all times, report when and as directed, be truthful in all statements that you make to the probation department. You're to keep them informed of your residence, place, of employment at all times, may not change either without prior permission, may not leave the state of Ohio at any time without prior written permission, may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who is an inmate in any of those facilities without prior written permission. Because of your conviction, you're prohibited under both federal and state law from purchasing, possessing, owning, using, or having under your control any kind of a firearm, ammunition, or dangerous ordnance. If you do that, you could be subject to being prosecuted for a felony in both jurisdictions. It's also a condition not have any of those items or any other weapons of any type while under community control in this case. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has an effect similar to controlled substances or drugs of abuse, nor may you have any instrument, device, or thing that may be used to administer those or prepare them for administration unless you have a lawful prescription for both the substance as well as the device or equipment. You must provide a copy of that prescription within 24 hours of receipt to the supervising officer. You must submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any type of an alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if it's otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, or any other person who has a criminal record, a member of a gang, or any other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions. unless that's approved in writing by your supervising officer. That includes any family members other than those you were living with at the time you committed this offense. And I want to point this out because you left the recovery council with some other person who undoubtedly you were doing drugs with. And that's why you can't associate with people like that, because it's a trigger and it's a real danger for relapse. So you're not going to do that, because if you do, you're going to be in violation. After this date of this order, you may not marry or establish cohabitation in a common law marriage type of relationship with another without written permission. You must report any contact with law enforcement on any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so that your ability to pay any fees, fines, or costs can be reviewed. Now, if you're referred by the probation department or your supervising officer for an evaluation or assessment for further treatment, therapy, counseling, training, educational programming, etc., you'll submit to that. If there's a recommendation you undergo any further programming, you're to enroll in and successfully complete that. You're to pay the court cost and make payment arrangements to do that. You're to successfully complete substance use disorder treatment at TCC. That's abbreviated as SUD in the entry, and TCC is the counseling center where you're at now. You're to complete that, as well as any aftercare they recommend. So if you complete the residential program and they tell you you should go into transitional housing or sober living, as well as continue aftercare, you're to do that. Now, as you know, they're not prison officials. They can't hold you against your will, but if you leave us then voluntarily, if you fail to follow through the recommendations, then you could be in violation of your community control. And that would also indicate you're not serious about your recovery. You're just trying to stay out of jail. And, just be aware of that. Now, you're also ordered to pay $40 in restitution to the Huntington County Task Force, and you make that monthly payments as directed by the probation department. So once you complete your residential treatment or working, they'll make a order for that. Now, you're also ordered to pay the court costs. It's a condition of your community control, but it's also a substantive order. And if you don't pay it or make payment arrangements to do it and comply with that payment plan, then the clerk can collect that through other means, including levying on bank accounts, wages, or other earnings you may have or assets you may have. And if that doesn't collect it, he can refer it to a collection agency or the Attorney General for collection. If that occurs, then in addition to the courthouse or court costs, you'll also have to pay a 30% fee to the collection agency. And if that doesn't collect it, then the court can order you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court. Each hour you worked will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have not complied, they will file a written notice of that with the court. There will be a hearing. You'll be entitled to have an attorney at that hearing. If the outcome of that hearing is that you failed to comply, then at that time the court can revoke your community control and sentence you to a term of imprisonment between 6 and 18 months and fine you $5,000. And if your revocation on community control is due in part or whole to a new conviction committed while under community control, then if you receive a sentence of imprisonment for that offense, that could be ordered to be served consecutively to the sentence in this case. Should you be sentenced to prison and complete the prison term, once that's completed, the adult parole authority may exercise the option to put you under what's called post-release control supervision for a period of up to 2 years. If they do, you'll be supervised under the conditions they set, and if they determine that you are not compliant, they can return you to prison to make you serve an additional period of up to 9 months for one or more violations. 9 months is the cap. Actually, the cap is half of whatever the term of imprisonment was. And so if it was less than 18 months, it could be, like say if it was 12 months, it could be 6 months. However, if you're convicted of a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that post-release control, whichever is greater, and if that occurs, that must be served consecutively to the sentence in the new case. All right, now that completes this case. You're no longer under pretrial supervision, but you will need to report now to the probation department to be transferred to a felony supervision officer. Is there anything further, counsel?
No, Your Honor.
All right, thank you. All right, looks like we have Mr. Jones on Zoom now, Ms. Barger, so if you can go hop on Zoom. All right, there are two cases before the court involving the same defendant. State of Ohio versus Travis L. Jones, 24 CR 145 and 22 CR 090. Now, are you Travis L. Jones appearing there from the jail?
Yes, Your Honor.
All right. This was set up as a Zoom hearing, and Ms. Barger was here for a in-person hearing, and Mr. King is also here, the prosecutor, so I just told them to stay here in the courtroom. Now, if you need to talk with your attorney, then I will excuse her from here, and she can go into a different room and log in, and then I'll put the two of you into a breakout room where the two of you can talk on the screen. No one else will be able to see you or hear you, and the deputy will step out of the room while that consultation is taking place, okay?
All right. Thank you, Your Honor.
Okay, so if that happens, you let me know, all right?
All right. Thank you. I will. Thank you.
Pardon me?
I will, Your Honor.
All right. Now, Ms. Barger, are you and Mr. Jones both in agreement this matter can be conducted with his presence by Zoom rather than being brought up here to the courthouse?
Yes, Your Honor.
And you're all right with that, Mr. Jones?
Yes, Your Honor.
All right. Now, in case number 24 CR 145, Mr. Jones has entered a plea to failure to comply with order signal police officer, a third-degree felony. The matter was referred for a pre-sentence report. I have received that. Have each of the attorneys received a summary?
State has, Your Honor.
Yes, Your Honor.
All right. Now, the other case before the court is 22 CR 090. And in that case, Mr. Jones was placed on community control for aggravated trafficking of methamphetamine on November 10, 2022. And he admitted to violating the terms of that order on October 17th. And due to this new conviction, the court defers sentencing on that until today as well. All right. Mr. Kane?
Thank you, Your Honor. In the 24 CR 145 case, I would just ask that the court follow the joint recommendation. And given that recommendation, I would ask in the 22 CR 90 case that the defendant be continued on community control in order to complete STAR. And it looks like there is a bed available for the defendant at STAR on November 13th. That's all, Your Honor. Thank you.
Ms. Barger?
Thank you, Your Honor. I've had multiple conversations with Mr. Jones. He's openly admitted that he made a grave error. He would like to be given the opportunity to correct his mistake. He does appear to want to get sober and want to get the help that he needs. It's just going to take more than an outpatient treatment facility to do that for him. He has never been to STAR before. I had multiple conversations with him about attending STAR and going there, which I will point out that was not his idea, it was mine, and he freely and openly wanted to go to STAR to be given that opportunity to get better and get on the right track so that he can be in his family's life and his children's lives at this time. He has a 1-year-old, and that is definitely a motivator for him at this point to get well, and he just wants to get well for himself so he can be there. We ask that the court would give him that opportunity and send him to STAR in both cases.
Anything you'd like to say, Mr. Jones?
No, Your Honor.
Well, one of the things I've noticed is in the pre-sentence report, your comment, well, you just made a mistake. I don't really think you've made a mistake. You knew there was a warrant out for you and you ran. I mean, there's no sense in trying to convince somebody that that's not the case. And so, you were trying to avoid being taken into custody. Now, you're here, and you say you want help, or you want to get clean. And what I will say to you is this. You're not going to get clean for your child. Nobody does that because it's an addiction, and you have to do it for yourself first. You have to focus on, you be quiet, I'm talking, okay? I gave you a chance to talk. You said you didn't have anything to say. Now it's my turn. I talk, you listen. Now, you need to make a decision to be sober. And not just for the purpose of trying to stay out of jail, because right now we can see that's not working. You got yourself in a bigger mess than you were in already before. Quite honestly, somebody that flees and eludes when they're already on community control and there's a warrant out for them, really more inclined to send you to prison than I am to give you community control. State's recommending it. I do realize that drugs are a problem, but you can't be committing these kinds of offenses when you're using drugs because you create a substantial risk of physical harm to a lot of people. When I read the report, the stop signs you ran and so forth, there was a lot of risk involved there. Unfortunately for you and others, no one else was hurt. So, I'm going to grant you community control and sentence you to a term of incarceration in case number 24 CR 145 to a term of 3 years of incarceration. I'm also going to extend or continue your community control in the 22 CR 90. I'm going to extend the period to make it 5 years. That's going to, so that it closer coincides with the 3 years here. Because I believe that entry went on in let's see here. That entry was filed on 22, it would have been up in 25. And so by extending you 2 years, that'll make it 27, that'll coincide with this. So your community control is extended to 5 years in that case. And all conditions that I'm giving you in the new case here, 24 CR 145, are to be complied with in the old case. Now, I know I've done this for you once before, but it's been a while, and I'm required to do it anyway in every case, no matter how much you know what I'm saying.
Your Honor, I apologize for interrupting you. I'm a little confused on his sentence at this point. You said a term of 3 years incarceration.
I'm sorry, 3 years of community control.
Thank you. I was
Okay.
very
That would
confused.
confuse somebody, wouldn't it? Yeah. Community control. I didn't mean to say, because like I said, incarceration was on my mind. But it's a term of 3 years of community control on 24 CR 145, and your term of community control is extended to 5 years in the 24 CR 145, or 22 CR 90, so they're both going to run together pretty much on time. Now, the conditions are, in both cases, you're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, be truthful in all statements you make to probation, keep them informed of your residence, place, and employment at all times. You may not change either residence or employment without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. You're already disqualified under both federal and state law from purchasing, possessing, owning, using, or having under your control any firearm, ammunition, or dangerous ordnance. You're not to have any of those while under community control in these cases. If you did, you could be prosecuted under both federal and state law in new cases, as well as being violated on this. You're not permitted to have any other weapons of any other type either. Now, You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has effects similar to a controlled substance or drugs of abuse. You may not have any instrument, device, or thing that may be used to administer those or prepare them for administration, unless you have a lawful prescription for both. You'll submit, and you must provide a copy of that to the officers within 24 hours of receipt. You're to submit to drug testing when and as directed. You're not permitted to purchase, possess, use, or have under control any kind of an alcoholic beverage, nor may be present in places where they're sold, being consumed, if it's otherwise lawful. You may not associate with anyone who's a co-defendant, if there were any, in either case, nor any other person who has a criminal record, a member of a gang or any other criminal group, or any person who has in the past or could in the future to influence you to commit a criminal offense or violates these conditions, unless that's approved in writing by your supervising officer. That applies to any family members that fall within that definition, unless you were living with them immediately before the commission of this offense. You're not permitted to marry or establish cohabitation or common law marriage type relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. Provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. Now, if you're referred by probation for any evaluation or assessment for further kind of treatment or programming, you're to submit to that. There's a recommendation from that evaluation or assessment that you undergo programming. You're required to enroll in and successfully complete that. You're required to pay the court cost of this action, make payment arrangements to do that. You're going to remain in the Highland County Jail because you are also going to be required to successfully complete the STAR program and any recommended aftercare. And there's a bed available, I believe, November 10, is it?
13, Your Honor.
13, yeah, 13, a week from today. You'll remain in jail until you're conveyed to STAR. You'll be required, as I said, to successfully complete STAR. Doesn't mean do pretty good and get there 80% of it in or 90%. It means complete it all, 100%. Because if you don't, I'm not going to waste any more time and resources on you. We'll send you to prison and then make those resources available to somebody else. Now, by being placed on community control, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you, used by you, or any other property or place that's under your control, or where you are found by any officer of the probation department. There'll be no fine imposed in this case. I am required by statute to send you to a mandatory term of suspension of your driver's license, and so that will be 3 years beginning today. That's the minimum suspension. Now, once you complete STAR and if you're showing you're making progress and compliant, the court will consider granting you limited driving privileges as applies to this case. I can only grant privileges for this case. You've got other suspensions. You have to take care of those, but I would grant it in this case if you have proof of financial responsibility. Now, you're also ordered to pay the court costs as a substantive order. You're required to do that as a condition, but it's also a substantive order. If you do not make payments on your court cost as agreed or pay them in full, then the clerk can collect that by various means. They could levy on your bank accounts, wages, or other earnings that you may have. They could refer to the collection agency, the Attorney General's office, to collect. And if that occurs, those people can charge you an additional 30% to collect above and beyond what you pay on the court costs. If that doesn't collect it, in any of those means, then the court could require you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have not complied, they will file a written notice of that with the court. There will be a copy given to you. There will be a hearing. You'll be entitled to be represented at that hearing by an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control and then sentence you in case number 24 CR 145 to a term of between 9 and 36 months. fine you $10,000, and in the 22 CR 90, I can sentence you to a term of 18 months, fine you $5,000. Those sentences could be ordered to be served consecutively, so that means a total of 54 months you have on the shelf that you could be required to serve. If you are revoked from community control because you commit a new felony while under community control in these cases, and you receive a prison sentence in that case, then the sentences in these cases in that case could be ordered to be served consecutively to one another, meaning one after the other. So that would add to that 54 months, depending upon what the offense was. Now, if you are sentenced to prison, upon completion of the prison term, it will be mandatory that you be placed under post-release control by the Adult Parole Authority for a period of at least 18 months, but no more than 3 years, as the APA or Adult Parole Authority determines. If they determine during that period of time that you have not complied with those rules, they can return you to prison as a sanction to make you serve an additional period of up to 9 months for a single violation, but there's a cap of half of whatever your prison term was for one or more violations. However, if you commit a new felony while under post-release control in these cases, then in addition to whatever sentence could be imposed in the new felony case by that judge could also sentence you for committing that offense while under post-release control in these cases to an additional term of 1 year, or whatever time was left on the period of post-release control, whichever is greater. And if that occurs, that would have to be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
Okay. I'm also going to put into this entry, and I see Ms. Sturgill's monitoring this, I'm going to refer your case to the drug court docket, and as you go through the START program, they'll be talking with you to see if you would like to apply for that. If that's something you have to apply for, I won't order you into it because it requires the person to be voluntarily in the program because they are determined to be sober and change their life. And so that'll be up to you whether you make that decision or not. But at some point, Ms. Sturgill will, or one of the other probation people will be talking to you about that. All right, you're remanded back to custody until you're conveyed to STAR. Thank you.
Thank you, Your Honor.
I'm in a really generous mood today. All right, 24 CR 22, State of Ohio versus Felina Harrison. Present on behalf of the state's Assistant Prosecuting Attorney King. Also present as attorney for record for the defendant is Attorney Sarah Barger. The defendant was granted intervention in lieu of conviction for aggravated possession of drugs on May the 3rd of this year. There was a motion to terminate filed on October 10 by the prosecutor's office, and it contained the notification of alleged violation from probation department. She's failed to report since May 28, 4 days after she was put in intervention. She's failed to comply with her treatment plan, failed to make any payments to the probation department for programming nor on the court cost. And it's alleged she's violated rules 3, 4, and 14. The court set the matter for hearing, and the defendant has not appeared. And I doubt that you've heard anything, Ms. Barger.
I have not, Your Honor.
All right, so the court will order a capias to issue Once she's taken into custody, we'll notify you, Ms. Berger, and schedule the matter for hearing. Thank you.
Thank you.
All right, this is State of Ohio versus Robbie L. Mion, 24 CR 130. And you are Robbie L. Mion appearing there from the jail? And we just lost the jail. Oh, there he is back. Are you Robbie L. Mion?
I am.
All right. This is a pretrial being conducted by Zoom. Mr. Munion's in custody of the sheriff's office. His attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. Defendant's charged with aggravated trafficking, aggravated possession of methamphetamine, third-degree felonies, and a forfeiture specification. And this is a final pretrial, and I believe the trial date is set for December the 19th. Now, is discovery complete on both sides?
It is from the state, Your Honor.
It is from the defendant as well. We filed ours on the 30th.
All right, and there have been no pretrial motions, correct?
Correct.
That's correct.
All right. What's the status of the plea negotiations?
My client has been made an offer. He's aware of the offer. He's advised me he's neither rejecting or accepting it yet, which is to have more time to think about it. I've advised him of the court's 2-week rule as far as pleas.
Right, okay. Well, he has some time, so. All right. Then anything else to consider at this point or discuss?
No, Your Honor.
All right. Your attorney may be in touch with you, Mr. Mion, and you can discuss this matter with him.
Okay.
Right. Thank you,
Your Honor.
All right.
Thank you.
Yes. Officer, do you have want to get those names out to him right away? All right. All right. This is case number 24 CR 136, State of Ohio versus Kevin Stewart. And you are Kevin Stewart, appearing there by Zoom from the probation department on the screen marked HCPD. You'll have to unmute yourself there, Mr. Stewart. There's a little button down in the corner. There's like a microphone, has a slash through it. Click on that. That'll unmute you.
There we go.
Okay. And you are Kevin Stewart?
Yes, Your Honor.
All right. This is set for a plea, and Mr. Stewart is represented by Dennis Kirk, appearing from his office by Zoom, appearing from the prosecutor's office is Mr. King. And Mr. Kirk, are you and your client both in agreement this hearing can be conducted by Zoom rather than personal appearance in the courtroom?
Yes, Your Honor.
And you're all right with that, Mr. Stewart?
Yes, I am.
All right. In the event you need to speak with your attorney during this hearing, just tell me and I'll put the two of you in a breakout room, and then it'll be just the two of you on the screen. No one else will be able to see you or hear you, okay?
Okay, Your Honor.
All right. Mr. Stewart is charged, looks like 3 counts of trafficking and fentanyl-related compound, 3 counts of possession. This matter is set for trial, looks like, on December the 9th. I have received a written plea agreement, and Mr. Stewart, what I'm looking at says you're going to plead guilty to counts 1 and 3. I'm going to hold this up to the screen, the camera. First page, it has a plea of guilty, your name, and the counts 1 and 3. Do you see that?
Yes, Your Honor.
And do you recognize that?
Yes, I do.
And on page 3, there is a sentence that reads, I enter this plea voluntarily. Below that appears to be the signature Kevin Stewart. And is that your name, or I mean your
Yes, it is.
signature? Okay.
Yes, Your Honor, it is.
Now, Mr. Stewart, when did you sign this document?
Yesterday, Your Honor.
All right, at your attorney's office?
Yes.
All right. And before you signed it, did he go over it with you and explain everything to you?
Yes, he did.
And you understood that when you signed it, that this is an agreement to plead guilty, meaning there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
And do you feel that you had enough time to fully consider the matter before making that decision to sign it?
Yes, I have, Your Honor.
All right, and you haven't changed your mind at all today?
No.
And you're going forward with this agreement to plead guilty voluntarily?
Yes.
All right, now the agreement states on page 1 that you're going to plead guilty to counts 1 and 3, both trafficking and a fentanyl-related compound under 2925.03A1 for 3 felonies. Further states that the penalty can be a prison term between 6 and 18 months on each count, and a fine of $5,000 and a possible license suspension of 6 months to 5 years on each count. And if you were sentenced to the maximum in each count, and those were to be served consecutively, it could be a maximum of 36 months and a fine of $10,000. Do you understand that?
Yes, Your Honor.
Now, are you facing any felony charges in any other jurisdiction?
No, Your Honor.
And I know you're on community control in this case, in this court. Are there any other cases or any other courts that you're on community control or probation for?
No, Your Honor.
Right. And you're not on post-release control for a felony?
No.
Now, under the law, if you should be convicted of these offenses and sentenced to prison upon completion of the prison term, it is possible the adult parole authority would put you on what's called post-release control for a period of up to 2 years. That means you'd be supervised by a parole officer in the terms the adult parole authority set, and if during the period of time that you were being supervised they determined that you had not complied, they could return you to prison, make you serve an additional period of up to 9 months for any one violation, but there is a cap or a limit of half of whatever prison term was imposed and served for all violations. However, if you commit a new felony while under post-release control supervision, then in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
Now, not required by law to sentence you to prison, I can impose what's called community control, which means that instead of being sent to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time the probation department felt you were not complying, they would file a written notice out with the court. There would be a hearing. You'd be entitled to be present at that hearing. And if the outcome of the hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for between 6 and 36 months and fine you the $10,000. And if you were revoked because a new felony had occurred, then and you were sentenced to prison for that offense, those sentences can be ordered to be served consecutively to the sentences in this case. Do you understand that?
Yes, Your Honor.
All right, now in count 1, it's alleged that on or about January 26, 2024, in Highland County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, to wit fentanyl, a Schedule II controlled substance, an amount equal to or exceeding 1 gram but less than 5 grams. And in count 3 alleges the same thing occurred on February 22nd, 2024. Both of those are then, as I said, trafficking and fentanyl-related compound 4-3 felony. Now, Mr. Stewart, do you understand what it is you've been charged with in those 2 counts, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
And have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, I did.
And are you satisfied with his advice and competence in this matter?
Yes, I am, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
I know you take prescription drugs, but are any of those drugs interfering with your ability to understand and comprehend what's going on here today and express your thoughts accurately?
No, Your Honor.
Okay. Now, has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Now, on page 2, there are 3+ lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1 and count 3. State will dismiss remaining counts. State defense will argue sentencing. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money to the task force the amount of $400. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, Your Honor. Just driver's license.
Right. Okay. Now, you have certain constitutional rights you must understand before I can accept your plea. First of all, you have a right to counsel, and I appointed Mr. Kirk to represent you.
Yes.
Now, I didn't appoint him simply to try to work the case out, but to provide any defense that could be available to you under the law that you'd like him to provide. So, if you decide that you do not want to do this, that you'd rather defend against the charges, he'll continue to represent you, including a trial, if that is what you want. You understand that?
Yes, I do.
Now, under the Constitution, Mr. Stewart, you have a right to have a jury trial on each of these charges in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. Once 12 of those folks are selected, the evidence will be presented. They'd be instructed on the law by the judge, and then that jury of 12 would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt on either of the two charges. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case you would have what's called a court or bench trial. And that means instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, I do.
Under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into open court and testify in the courtroom in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that would be to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, I do, Your Honor.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So, if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, Your Honor.
Now, under the law and the Constitution of the United States and the state of Ohio, you have a privilege against self-incrimination, which means you cannot be forced to give evidence about this case at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. And if you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. No one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Under the Constitution, Mr. Stewart, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that that you do not have to try to prove that you're innocent simply because you've been accused. In fact, under the law, you don't have to present any evidence at all in your defense. You may, but you're not required to. But whether you do or not, the burden of proof is upon the state of Ohio to prove your guilt on every essential element of each of these offenses by proof beyond a reasonable doubt, which is the highest burden of proof that is known under the law. Do you understand that?
Yes, Your Honor.
Now, originally you entered a plea of not guilty, Mr. Stewart. Plea of not guilty denied the allegation, an indictment denied you committed any crime, and exercised or invoked all the rights that I've just described for you. Now, if you change your plea today from not guilty to counts 1 and 3, those are the complete opposite of the not guilty plea. The guilty plea would admit the allegations in count 1 and 3, admit that they're a crime, that you committed that crime, and that plea would waive or give up all the rights that I've described for you today except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception. Your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront the witnesses against you, cross-examine through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses being in court to testify on your behalf, the same as the state. Would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It waives or gives up your right to file an appeal on any alleged errors you feel may have occurred in your case up until this point. Now, if you should be sentenced to the maximum sentence or under other limited circumstances, you could file an appeal. That appeal will have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, Your Honor.
Now, also, Mr. Stewart, you're on community control in another case, I believe, for permitting drug abuse. And one of the conditions, and I believe that it's alleged that these offenses occurred while he was on community control. Is that correct, Mr. King?
Yes, Your Honor.
That's correct, Your Honor.
All right, and so in the event that you are convicted in this offense, in this case, then that would mean a violation of your conviction in the other case, and I believe that's a 5th-degree felony, and so that would subject you to being sentenced for that offense as well. It could be used to revoke your community control and sentenced in that case for a period of between 6 and 12 months, and that sentence could be ordered to be served consecutively to the sentence in this case. Do you understand that?
Yes, Your Honor.
Okay. Now, are you a U.S. citizen?
Yes, I am.
Do you have any questions about the charges or the penalties?
No, Your Honor.
You
I
understand? Okay.
Yes.
And you understand the consequences in your other case if you are convicted in this case?
Yes, Your Honor.
Okay. Do you have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, I do, Your Honor.
Have any questions about your constitutional rights that I've explained here today?
No, I don't, Your
You
Honor.
understand those?
Yes, I do.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, I understand everything, Your Honor.
All right. Do you need to speak with your attorney about anything before we go any further?
No, Your Honor.
All right. And I don't know if I said this at the beginning, but Mr. Kirk, you and your client are both in agreement this matter can be conducted by Zoom.
Yes, I believe you asked that, and we are.
Did I
yes.
ask it? Okay. All right.
I think so.
All right. Is there anything, you have any questions at all, Mr. Stewart?
No, Your Honor, I don't.
That is it your decision to withdraw your not guilty plea, plead guilty to counts 1 and 3 in accordance with this plea agreement we've just gone over?
Yes, Your Honor.
And you're doing that voluntarily?
Yes, I am.
Then as to count 1, which alleges that on or about January 26, 2024 in Huntington County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, to wit fentanyl, a Schedule II controlled substance, an amount that equals or exceeds 1 gram as less than 5 grams in violation of Section 2925.0381 of the Ohio Revised Code, a 4th-degree felony carrying a possible prison term between 6 and 18 months and a fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
As to count 3, which alleges the same offense except that it's alleged to have occurred on February 22, 2024, otherwise the same language, the same offense, the same penalties, how do you plead?
Guilty, Your Honor.
All right, the court finds that on this date in open court, the defendant was advised of all of his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to Criminal Rule 11. Plea is accepted, ordered, filed. The defendant is found guilty of counts 1 and 2. I'm sorry, counts 1 and 3. The second count, counts 4 through 6, are dismissed. Court will set the matter for sentencing on December 3rd at 1:30 p.m. Bond will be continued. I'll refer the matter back to probation for an updated PSI. I know we have one from, it's about a year old or maybe a little over a year old. But anyway, we'll have an updated report for that. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. All right. Number 23, CR 157, State of Ohio versus DeAndre Wilkerson. And you are DeAndre Wilkerson, appearing there from the jail.
Yes, sir.
All right. The defendant was placed on community control on February 24th of this year for aggravated possession of methamphetamine, a 5th-degree felony. The court received a notification of alleged violations of community control filed yesterday. And Ms. Wilkerson, it alleges that you have violated Rule 2 of that order, and that on or after July 30 of 2024 you failed to report. Rule 3, that you made your whereabouts unknown after July 30th of 24. Rule 7, that you had, it looks like 5 different occasions in which you tested positive for controlled substances or prohibited substances. And Rule 13, that on or about July 15th of 24, you were suspended from services for failure to comply with, it doesn't say who the, I guess it was TRC, yeah. And then you referred to reach, and you failed to show for an assessment. And in Rule 19, that you were suspended for services from TRC for failure to complete their program as ordered by the court. And that would be Rule 19A. All right, now, you're entitled to have a hearing on this matter in which the state will be required to prove that you have failed to comply with these conditions. And you do have a right to have counsel, and if you do not have the money to hire counsel, the court will appoint one for you. And I believe you did fill out a financial disclosure form. Is everything on this form correct? All right. The court will find that you are indigent, and I will appoint Attorney Catherine Hapner to represent you. You'll be held without bond until the hearing. We'll schedule an evidentiary hearing on November the 18th at 9:00 a.m. We'll notify your attorney of her appointment. Do you have any questions?
No, sir.
All right, thank you. Marshall Smith. And then do we have those other cases for arraignment? Okay.
Yes, see, I'm your shit for it. There you go.
All right, this is case number 23 CR 106, originally titled as Marshall C. Heiss, but I believe is also known now as Marshall C. Smith. And is that your name, Mr. Smith, appearing from the jail?
Yes, sir.
All right. All right, the defendant was placed on community control on September 7th of 2023. The charge in that case was theft by deception, a 5th-degree felony. Now, representing the state is Assistant Prosecutor King, and Mr. King was the victim of the offense notified of the time, place, and purpose of this hearing and the right to be heard.
Yes, they were, Your Honor, and they've elected not to appear.
All right. All right, Mr. Smith, there was a notification filed by the probation department yesterday that alleges that you have violated the conditions of the September 7, 2023 order. Rule 1, and that on October 12 of this year you were convicted or charged with, and on October 16 of this year you were found guilty of obstructing official business in a Highland County court. Rule 2, that on or after August 29, 24, you failed to report as instructed. Rule 3, that you made your whereabouts unknown after that date. Rule 7, that you tested positive for prohibited substances on, it looks like, 4 different occasions. Rule 11, that after your release from the Ross County Jail on October 17th, you made no contact with your supervising officer. And in Rule 13, you were referred to reach for tomorrow for outpatient services and have not attended since June of this year. And in Rule 15 that on before the 4th of November, I believe it may have been the day you were arrested, you failed to pay court costs. Now, you have a right to have a hearing on these matters in which the state will be required to prove that you have committed these violations. You do have a right to have counsel, and I see that you have filled out an app or a financial disclosure form. Is everything on this correct?
Yes, sir.
All right. Now, it says you're making $3,000 a month at Greenfield Products. How long have you been there?
I was working up till the time of my
Arrest.
arrest.
All right. Well, the court then will find that you are entitled to counsel, and I'll appoint Attorney Dennis Kirk to represent you. We'll set this matter for hearing on November 18 at 9 o'clock. And you'll be held without bond until that time. We'll notify your attorney of his appointment. Do you have any questions?
Yes, sir.
All right, thank you. All right. And then, Deputy, if you have those, already got them out. All right, are you Randy Alexander Jr. appearing there from the jail?
Yes, sir.
All right, this is case number 24-CR-150, State of Ohio versus Randy Alexander Jr. Mr. Alexander is appearing by Zoom from the jail. Mr. Alexander, you were indicted by the grand jury yesterday on a single count of aggravated possession of methamphetamine, a 5th-degree felony. And that charge allegedly occurred on or about July 31, 2024 in this county, and alleges you knowingly possessed or obtained or used methamphetamine. If convicted, that carries a possible term of incarceration of 6 to 12 months and a fine of $2,500 and a possible license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you in this matter. And if you don't have the money to hire one, the court will appoint one for you. And I believe, yep, there it is. You filled out a financial disclosure form, Mr. Alexander, and is everything on the form correct?
Yes, sir.
All right. Court then will find that you're entitled to appointed counsel. This is the first time you've been in court on this case?
Yes, sir.
All right. The court will appoint Attorney Sarah Barger of Hillsborough, Ohio, to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set a bail review hearing by Zoom for Friday, November 8 at 8:30 a.m. first pretrial will be November the 20th at 1 p.m. Your final pretrial will be December the 11th at 1 p.m. Trial date will be January the 13th at 8 a.m. And I understand you're being held right now on a misdemeanor, is that correct?
Yes, sir.
How long have you got on that?
Well, under 90 days.
All right. Well, I'll set bond in this case at $2,500 plus an OR. And that's your promise to appear. And if you fail to appear, you could be prosecuted for a felony on that. You'll be required to pay a deposit of $171 prior to release. If you do make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. We'll be required to report to them immediately upon release, and then once a week for 4 weeks after that as they determine, undergo random drug testing by order, provide phone numbers for Holmes' employer. It's recommended by probation. You'll be evaluated for substance abuse and mental health issues. Any treatments indicated, you enroll in and follow that during pendency of this action. You'll also be under house arrest at your residence. Meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. Points with an attorney or probation officer in this or any other case, contain any kind of educational programming, schooling, etc., church services, and family holiday events, if you have any. Otherwise, you have to be there at all times, and if you fail to comply, then the court could revoke that and have you held till further order of court. All right, we'll notify your attorney of her appointment, and as I said, we'll have a Zoom hearing Friday morning. All right, thank you. All right, going to bring in Mr. Howen. All right, case number 24 CR 149, State of Ohio versus Ronald L. Howland Jr. Are you Ronald L. Howland Jr.?
Yes, sir, Your Honor.
All right, Mr. Howland, you were indicted by the grand jury on a charge of possession of heroin, a fourth-degree felony yesterday, and it alleges that on or about the 4th of October, in this county, you knowingly obtained, possessed, or used heroin in an amount over 1 gram, less than 5 grams. That is a fifth-degree felony, which carries a possible term of imprisonment of between 6 and 18 months, and a fine of up to $5,000, and a possible license suspension of 6 months to 5 years. You are entitled to have an attorney to represent you in this matter, and if you don't have the money to hire, the court will appoint one for you. You filled out a financial disclosure form, Mr. Howland. Is excuse me, everything on this form correct?
Yes, sir, Your Honor.
All right. Court then will find you are entitled to appointed counsel. Who was your attorney in the last case you had here?
I'm not sure, Your Honor, but I had Danielle Witt for Greenfield. I really, she influenced me to waive my right to a preliminary hearing, and I don't feel like that was proper.
Well, that that attorney just handles that kind of thing. I'm not going to appoint him because he doesn't practice full time. So I will.
David Wagner, I think, was mine.
Okay, I'll go ahead and appoint Mr. Wagner then to represent you in this case, and enter a not guilty plea on your behalf. We will set a Zoom bond review hearing for Friday morning at 8:30 by Zoom. Your first pretrial will be November the 18th at 1:00 p.m. Your final pretrial will be December the 11th at 1 p.m. And we're going to go ahead and set your trial for the 18th. That's pretty quick, but I think the time deadline is the 31st. So we'll go ahead and set that for 8 a.m. That can be granted a continuance if you need more time. You and your attorney once you talk. The court will set bond in the amount of $2,500 plus your own recognizance, which is your promise to appear. If you fail to appear, then you could be prosecuted for an additional felony and convicted, sentenced on that no matter what happens in this case. You'll be under pretrial supervision of the probation department at 117 East Main Street. You report to them immediately upon your release. If you make bond, then you'll be required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues, any treatment indicated. You're enroll in and follow that during the pendency of this action. You'll also be under house arrest at your residence at 11905 State Route 28 West in Greenfield, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of job training, educational programming, schooling, etc., church services, and since we're in the holiday season, if you do make bond, you'll be permitted to attend any family holiday events. Other than that, you have to be there at all times, and if you fail to comply, then the court could revoke that and have you held to further order of the court. All right, we'll notify your attorney of his appointment. We'll have your bond review hearing Friday morning. All right, thank you.
Thank you, Your Honor.
Mr. Nukem, you were indicted by the grand jury yesterday on a failure to register a change of address as a registered sex offender, third-degree felony. Alleges that on or about September 11, 2024, and after in this county, that being a registered sex offender from an Adams County Common Pleas Court case, that you failed to provide, having a duty to register, you failed to provide a notice of your change of address within 20 days, that your conviction was gross sexual imposition of fourth-degree felony, you were a Tier 1 registered offender, and that you had previously convicted of failure to register in this court on August 24, 18, in case number 18 CR 132. So that is a third-degree felony, which carries a possible prison term if convicted between 6 and 18 months, a fine of $10,000. Now, you are entitled to have an attorney to represent you in this matter, and if you don't have an attorney, the court will appoint one for you. I see you did fill out a financial disclosure form, and is that everything on that correct?
Yes.
All right, and did you, you didn't have an attorney on this case before today? Okay. Court will appoint Attorney Danielle Witt of Hillsborough, Ohio to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set a bail review hearing by Zoom for Friday morning, November the 8th at 8:30 a.m. First pretrial will be November the 20th at 1 o'clock p.m. Final pretrial will be December the 3rd at 2:30 p.m. And your trial date will be set for December the 19th at 8 a.m. Bond will be set in the amount of $10,000 plus your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. You'll be required to pay a deposit prior to release of $171 for certain statutorily required fees. If you do make bond, you'll be required to be under supervision of the probation department. You'll report to them immediately upon your release. Then be required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, and employer. Recommended by probation to be evaluated for substance abuse or mental health issues. If any treatments indicated, you enroll in and follow that during the pendency of the action. You'll be under house arrest at your residence, meaning you have to be there at all times unless you are going to and from work, medical appointments, court proceedings, in this or any other case, appointment with an attorney or probation officer in this or any other case. You can also attend any kind of job training, educational program, and church services and any family holiday events during the holiday season. Otherwise, you have to be there at all times, and you'll also be required to register as sex offender upon release. I will notify your attorney of her appointment, and we'll have the review hearing Friday morning. All right, we'll notify her of the appointment. Thank you. That's everybody?
Your Honor, we got a Rachel Button we brought back to Twin Valley yesterday.
Okay, Rachel Button. I think that maybe, hold on a minute, let me get Miss Boyer in here. I'm not sure when that's set for hearing.
Seen her on our list this morning. Maybe we could actually hold her till.
Yeah, it's not on the docket, but let me get my assignment commissioner. We'll find out what's going on here. They have Rachel Button out at the jail. When's the hearing?
They said they do, but I have not gotten an evaluation yet.
Oh, okay. Well,
That happens, they'll just
All right, this is case number 24, CR 133, State of Ohio versus Preston. Crest, are you Preston Crest appearing there from the jail? Can you hear me, Mr. Crest? Can you hear me, Mr. Crest? No.
That is him, Your Honor.
Yeah, I know it is. I'm just trying to get him to be able to communicate with us. All right, now, Mr. Crest, can you hear me? Nope. All right, can you hear me, Mr. Crest?
Jail's logging out and logging back in.
Yeah, I know. All right.
Yes, Your Honor.
All right, we have two cases, 22 CR 245, 23 CR 039, both involving the same defendant, Sylvia Cutler. Ms. Cutler is appearing by video, by Zoom. On the screen marked Sylvia Cutler. Her attorney is Danielle Witt, appearing on her phone and appearing on behalf of, from her office, I should say. And appearing from the prosecutor's office is Assistant Prosecutor Adam King. Now, in 22 CR 245, defendant is indicted for one count of aggravated possession of methamphetamine. See, I believe this was an ILC that was granted, and a hearing was set on January the 18th. Okay, we can hear you now, so I'm going to go ahead and mute you. I've got another hearing going on, and we'll do him right after that.
Yes, Your Honor, apologize.
Okay, no problem. All right. That defendant was advised of the allegations on October 24th, and then the matter was set for a pretrial today. And then in the meantime, this Cutler was indicted in case number 23 CR 39 for failure to appear, and she was arraigned on that charge, and Ms. Whip was appointed to represent her, and the matter was set for a pretrial today. Final pretrial set on that case on 12/11, and trial is set for January 13. Okay, now, with regard to the newer case, I see there's been a request for discovery that was just filed today. You received that, Mr. King?
Yes, and discovery has been provided, Your Honor.
All right. All right. Now, on the new case, do you anticipate any pretrial motions, Ms. Witt?
No, Your Honor.
All right. And so we don't really have any written plea offer yet?
It's an offer has been provided in each case, Your Honor.
Oh, okay. Did you receive it yet, Ms. Witt?
I do. I have.
All right. Is your client aware of it?
Not yet. I need to find out where she is and everything.
All right. Where are you, Ms. Cutler?
I'm at my home.
Well, that's a place, not a location. Tell me the address.
42 Price Lane, Piketon, Ohio.
All right. And what is your phone number there that Ms. Witt can reach you?
It's 740-649-1139.
All right. So she's going to get in touch with you. You need to stay in touch with her so that we can move forward on these cases. I'll just continue the matter of the ILC until the next pretrial as well, which is December 11.
Okay, thank you.
All right. Are there any other matters we need to discuss on this case then?
No, Your Honor.
No, Your Honor.
All right, Ms. Cutler, make sure you get in touch with your attorney as well. Don't just wait for her. It's not her job to chase you down. She's representing you, so you need to be in touch with her. So you need to give her a call and set up an appointment so you can discuss these cases with her. All right? Okay.
Thank you.
All right. And have you been reporting to probation?
Yes, Your Honor, I have.
Pardon me?
Yes, Your Honor, I have.
Okay. She's been reporting all right, Ms. Benson?
Yes, sir. She bonded out yesterday and reported in.
Okay. Well, you need to report once a week for the next 4 weeks in person. So you need to make sure you keep that schedule. All right? Thank you. All right. Let's go back to Mr. Crest now. Case number 24 CR 133, State of Ohio versus Preston Crest. And you're Preston Crest appearing there from the jail?
Yes, Your Honor.
All right. Mr. Crest, this is a pretrial. Mr. Crest is represented by his attorney, Jacob Wagner. Assistant Prosecutor King represents the state. Defendant's charged in a 5-count indictment. Matter is set for trial, I believe, on November 14. It was set pretty quickly because of the speedy trial concerns, and so this is only 8 days prior to the pretrial. But the court did receive a motion for continuance that was filed yesterday and signed by both Mr. Wagner and Mr. Crest, requesting the court continue the trial. and waiving any speedy time limit. And the state receive that motion?
Yes, Your Honor.
All right. And the state is the state in opposition to the motion?
No, Your Honor.
All right. All right, so Mr. Crest, you're in agreement with that, and you're agreeing to waive your speedy trial time?
Yes, Your Honor.
All right. I think I actually spoke with counsel, and I believe we came up with a date of December 16, I believe. Yeah, that's a Monday. That's normally a civil day, but we're going to continue it to that day because I already have a whole bunch of other cases on the 9th and the 12th. So it'll be December 16th at 8 a.m. And time will be charged to the defendant. All right, anything further from, the discovery is complete?
It is from the state, yes, Your Honor.
All right.
You filed, yes, Your Honor.
All right, there are no pretrial motions?
Not that I see, sir.
And is there,
May I address the court, Your Honor?
Yeah, go ahead.
Your Honor, Mr. Crest and I have been talking for quite some time on his case. Today, again, we spoke. It appears that he's going to be retaining new counsel. I've advised him, typically of this court's rule, that new counsel will need to be ready on December 16th. That being said, Your Honor, Mr. Crest did request that I ask the court to, I guess it's kind of moot now, but to continue this pretrial or to set another pretrial for new counsel to be able to, I guess, review the evidence and have a pretrial, Your Honor?
Well, there's not another attorney yet, so until there's an attorney that's actually entered an appearance, I'm not going to do anything. Mr. Crest, if you hire another attorney, you need to tell them to be ready to go to trial on December 16th, because I don't let people wait to the last minute like this is, which is 8 days from the trial date, and then say, okay, now I'm going to hire another attorney, and that attorney's going to come in and say, okay, well, I need more time, blah, 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 blah. So you need to make sure your attorney understands that if they're going to represent you, they need to be ready to be available on the December 16th, because I'm not going to grant any more continuances because you waited all this time to hire your own attorney. I mean, you were indicted on the 1st of October. This case has been hanging around longer than that because you were bound over. So, if you're going to hire a new attorney and pay for him yourself, then you need to get it in gear and get it done immediately, and tell that attorney to enter an appearance. And then if that attorney wants to request another pretrial or whatever, then we'll talk about it. Also, keep in mind, don't interrupt me when I'm talking. Keep in mind, I have a 14-day rule, and I was, going to waive for this case because I had to set your case quickly because of speedy trial concerns. But that means that's December the 2nd. So that means you need to get your new attorney, and they need to get involved and get in touch with the prosecutor and decide if this case is going to be tried or if there's going to be a resolution. If there's going to be a resolution, then it needs to be done before December the 2nd. You understand?
Yes, Your Honor.
All right. Do you have any questions?
No, Your Honor.
All right. Do you actually have an attorney that you've contacted?
Yeah, my mom got it.
I've actually spoken to the attorney, Your Honor. I told him I'd send up the discovery. Should he put a notice of appearance on, I know who it is. I have his phone number. We've already talked about the case. So once I get the notice of appearance, I'll send my discovery to him.
Okay. So he's going to enter an appearance, is what he told you?
If the retainer gets paid, it appears that he may.
If the retainer gets paid, okay. So that's always the big if. So has your family paid this attorney yet, Mr. Crest? Do you know?
Yeah, they're in motion of doing so now.
Well, I know. I mean, in other words, they're in the process of doing it, but they haven't. And that's always the concern, because in my experience, and I've done this for 48 and a half years, attorneys aren't going to enter an appearance until they get the money. And again, you need to tell your family, don't be expecting that they can pay him by the 15th of December, and he comes in here on the 16th of December, says, I just got paid, I'm not ready. And until there's an attorney of record in this case, Mr. Wagner's your attorney. And if he hasn't entered an appearance by December the 2nd, then I'm going to probably not excuse Mr. Wagner. He's going to be your attorney, and you can have this co-counsel come in on December 16th and try it as co-counsel, but I'm not going to, mess around, So I'm not like most judges that let defendants just, make all kinds of decisions at the last minute and so forth and so on, I recognize a stall when I see it, and I'm not going to go for it. Understand?
Yes, Your Honor.
All right. Anything further from council?
No, Your Honor. Yes, sir.
All right, thank you.
Thank you, Your Honor.
right, are you Dylan Downs appearing there from the probation department?
Yes, sir.
All right, this is case number 24 CR 126, State of Ohio versus Dylan Aaron Downs. Mr. Downs is appearing by Zoom from the probation department. His attorney is Danielle Witt, appearing from her office, appearing from the prosecutor's office, Assistant Prosecutor King. The defendant is charged with 1 count of aggravated possession of methamphetamine, a 5th-degree felony. This is a final pretrial, and the trial was set for December the 9th. This is, I do have a plea of guilty form, so Ms. Witt, do you and your client both agree that this matter can be conducted by Zoom rather than in-person appearance?
Yes, we do.
All right, and that's all right with you, Mr. Downs?
Yes, sir.
All right, now if at any time during this hearing you decide you would like to speak with your attorney or ask her a question, since you're not in the courtroom, you just speak up and tell me, and then I'll put the 2 of you into a breakout room. It'll be just the 2 of you on the screen. No one else will be able to see you or hear you during your discussion, okay?
Okay, thank you.
Now, I have this form that says you're going to plead guilty, Mr. Downs. I'm going to hold up to the camera the first page, which has your name, case number, plea of guilty, and the charge there. You see that form?
Yes, sir.
You recognize it?
Yes, sir.
All right. On page 3, there's a sentence that reads, I enter this plea voluntarily, and right below that is the signature appears of Dylan Downs. And I'll hold that up to the screen, and is that your signature?
Yes, sir.
When did you sign this, Mr. Downs?
It was the last court date that
Okay.
I was here for. I left and went over to Danielle's office immediately after, and I went and talked about it.
All right.
Seen my delivery, and then we talked about it, and I went ahead and signed it.
All right. Now, when you signed it, you understand it was agreement to plead guilty, meaning there's not going to be a trial. The next step in your case will be a sentencing hearing.
Yes, sir.
And I know it's been a couple of weeks or maybe longer since you've signed it. Have you had any change in thoughts? Have you changed your mind, or are you still sure this is what you want to do?
I'm sure this is what I want to do, sir.
And you're going forward today with this plea voluntarily?
Yes, sir.
All right. Now, the agreement states, as I said, you're going to plead guilty to the charge, which is aggravated possession of methamphetamine, a 5th-degree felony under 2925.11 of the Ohio Revised Code. And it states you understand that carries a possible sentence of between 6 and 12 months incarceration, a fine of $2,500, and a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
And are you facing any felony charges anywhere else?
Ross County. I was actually about to be coming off of probation in December over there, and it was for domestic violence that happened, I'm wanting to say about 3 years ago.
Was that a misdemeanor or felony?
It was a felony.
All right. And you're on probation for that now?
Yes, sir.
Okay. Other than that charge, any other cases?
No, sir.
All right. Now, under the law, if you are convicted of this offense, that could be considered a violation of that probation or community control in that other case, which means that it could be, if the probation department feels that they should, they may file a request to have that considered as a violation and have you revoked, which means you could face a sentence, prison sentence on that offense. You understand that?
Yes, sir.
That's what's called a collateral consequence of a plea in this case.
Yes, sir.
Now, and in the event that you got sent to prison on that case and this case, it's possible that you could be ordered to serve sentences consecutively, meaning one after the other. You understand that?
Okay. Yes, sir.
Okay. And you're not on, other than that case, you're not on probation or community control or parole or post-release control for felony?
No, sir.
All right. Now, under the law, if you should be convicted of this offense and sentenced to prison, it is possible the adult parole authority would put you under what's called post-release control once you completed the court sentence. That's up to them. It's not mandatory. It's optional. But if they do, you could be supervised by a parole officer in the terms they set for up to 2 years. And if during that period of time they determine that you had not complied, they could return you to prison to make you serve an additional period of up to 1/2 of your prison term that was actually imposed for one or more violations. But if you are convicted of a new felony, then in addition to whatever sentence could be imposed by the judge in that case, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively, sentence in a new case. You understand that?
Yes, sir.
Now, I'm not required by law to sentence you to prison for this offense. I can impose what's called community control or probation, which you're familiar with in your Ross County case. That means you're supervised by a probation officer under terms set by the court. And that could be for up to 5 years. And if during that period of time the probation department felt that you were not complying, they could file a written notice of that with the court, give you a copy, and you would have a hearing. And at that hearing, you'd be entitled to have an attorney. And if the outcome of that hearing was you failed to comply, then at that time, they could, the court could revoke your community control and then sentence you to prison for 6 to 12 months and fine you $2,500. And if you should be revoked because you committed a new felony offense, which is possible here in this scenario with your Ross County case, and if you were sentenced to prison on both this case and the case that you committed while under community control, then those sentences could be or be served consecutively to each other, meaning one after the other. Do you understand that?
Yes, sir.
All right. Now, the charge in this case alleges that on or about January 27, 2024 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, methamphetamine. So that's the charge with the penalty I just described.
Yes, sir.
You understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses that might be tried to raise to trial, and a possible outcome of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, under the agreement states on page 2 that you will enter a plea of guilty to the indictment, and the state and defense are both recommending that you be granted community control and be referred to drug court. Now, is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentencing as well as admission into drug court is up to the judge, not the parties. And so if you plead guilty, once I've heard all the information, if I decide that's not the appropriate sentence, you could be sentenced to a term of incarceration and fined $2,500. Do you understand that?
Yes, sir.
Also, you could have your license suspended for 6 months to 5 years.
Yes.
All right. Now, and then also whether or not you go into drug court, first of all, I don't order that. You have to apply. You have to be screened. And then the court makes a determination whether you're eligible or not and whether you would be a suitable participant. You understand that?
Yes, sir.
All right. Do you hold any license or certification from any state governmental agency that regulates any occupation, trade, or profession in the state of Ohio?
I got a trade under me for welding that came from the store.
Okay. All right. Well, that's I think that's a occupational certification from a trade group, but it's not a governmental agency. So the only reason I ask that is we have to notify governmental agencies of convictions. We don't have to notify trade organizations.
Okay.
Okay. Now, you have certain constitutional rights you must understand before I can accept a plea from you. First of all, you have a right to have counsel, and Ms. Witt was appointed to represent you. That wasn't simply work the case out, but to provide any defense that may be available to you under the law that you'd like her to provide. So if you decide you don't want to do this, that you would rather defend against the charge, she'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution and the laws of the state, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those people are selected, the evidence would be presented. The judge would then instruct them on the law, and then that jury of 12 would have to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
All right. Now, under the Constitution, you have a right to use, or you have a right to confront the witnesses against you in open court, cross-examine them through your attorney. That means as witnesses against you have to come into court, testify in public in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions, which is called cross-examination, the purpose of which is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, your request court issues a court order is called a subpoena, and that forces those people to come to court to be able to testify if you want them to, even though they don't want to be here. It's the same way the state's witnesses are required to come to court to testify against you. You understand that?
Yes, sir.
Under the Constitution, you have a right to, you have a privilege against self-incrimination, which means you cannot be forced to give evidence against yourself in this case at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, it's your decision. You decide not to testify. The fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you decide not to testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
All right, now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at trial in your own defense. You can, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Originally entered a plea of not guilty, which denied the allegation in the indictment, denied you committed any crime, and exercised all the rights I've just described. If you change that plea today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, and that you committed that crime. That plea waives, gives up all the rights I just went over with you, except one, your right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. Waives gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives gives up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. Waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what you use to find you guilty. And waives gives up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. And also, waives gives up the right to file an appeal on any alleged violations of your rights you feel could have occurred up until this point in the case. Now, if I sentence you the maximum sentence, or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentence and entry being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
All right. Now, do you have any questions about the charge, the possible penalty?
No, sir.
You understand it?
Yes, sir.
Any questions about the constitutional rights I've explained?
No, sir.
You understand it?
Yes, sir.
Understand the plea agreement?
Yes, sir.
You understand that the recommendation of the state's not binding on the court?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yeah, no, sir.
All right. Do you need to speak with your attorney or ask her any questions before we go on?
No, sir.
Do you have any questions at all about what I've talked about here today?
Nope.
And are you a U.S. citizen?
Yes, Your Honor.
All right. And is it your decision to go forward and plead guilty in accordance with the terms of the plea agreement to the charge in the indictment?
Yes, Your Honor.
Then as to the charge which alleges that on or about January 27, 2024 in Highland County, Ohio, that you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, fifth-degree felony with possible penalty of 6 to 12 months in prison, possible violation of your community control in Ross County with a prison term, and a fine of $2,500 and a license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right. The court finds on this day in open court, defendant was advised of all of his constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal 11. Please accept the order filed. Defendant is found guilty of the charge in the indictment. The matter is referred to the probation department for a pre-sentence investigation, which shall include an assessment for substance use disorder and mental health issues. The case is also referred to the drug court docket. So you'll need to speak with Officer Benson and make sure that you get your appointment for your pre-sentence interview and your drug court referral interview.
Okay.
All right. Sentencing will be on December the 11th at 9 a.m. and bond will be continued.
Okay, thank you, Your Honor.
All right, thank you. All right, would you bring in Mr. Seagraves next, Officer Benson?
Yes, sir. You are unmuted, you're ready to go.
All right, are you Matthew Seagraves there at the probation department?
Yes, sir.
All right, this is case number 24 CR 118, State of Ohio versus Matthew Seagraves. This is a final pre-trial. Mr. Seagraves is charged with 2 counts of assault on a peace officer, both fourth-degree felonies. Mr. King has the alleged victim of the victim or victims of the offense been notified of the time, place, and purposes hearing the right to be heard?
Yes, Your Honor, they have been notified and they've elected not to appear today.
Okay. All right. This matter is a final pretrial. The case is set for trial on December the 9th. Is discovery complete from both sides?
It is from the state, Your Honor.
Will be filing my compliance later this afternoon.
Okay.
What?
All right. Now, and there are no pretrial motions, correct?
There are not.
Okay. Okay. And what's the situation with any plea negotiations?
I'll be meeting with my client next week, and I believe we'll have the matter resolved prior to trial.
Okay. You have an appointment already set up?
I've not spoken with him directly, spoken with his sister to schedule that.
Okay. You're aware of the appointment, Mr. Seagraves?
What day?
Are you aware of your appointment your sister made for you with Miss Hapner?
For next Friday afternoon?
When?
Next Friday afternoon.
Next Friday.
Is that the 8th or the 15th?
Oh, I'm sorry, the 15th.
All right, so it's not this
I'm sorry,
coming
I guess I
Friday.
wasn't clear.
It's a
Yeah.
week from Friday, so mark that down. 15th of November, and what time?
At 2 p.m.
2 p.m. at Miss Hapner's office. So you need to get there, whether it be through your sister or however you need to get there, okay?
I didn't spell that. Okay.
All right.
Do I need to see Benson?
You check with the probation department before you leave. Yes, that's correct.
Okay.
All right, thank you.
Thank you.
All right, who else you have there, Miss or Officer Benson? All right, this is case number 24 CR 128, State of Ohio versus Christopher Ernest Holt. Are you Christopher Ernest Holt appearing there from the probation department?
Yes, sir.
All right. This hearing being conducted by Zoom. Mr. Holt's attorney Sarah Barger appearing from her office, appearing from the prosecutor's office representing the state is Assistant Prosecutor King. The defendant is charged with 1 count of aggravated possession of methamphetamine, a 5th-degree felony. This is the first pretrial, or I'm sorry, the final pretrial, and have a trial date set of December the 9th. Now, I've been given a plea of guilty form, Mr. Holt, which indicates you're going to plead guilty to the charge. Ms. Barger, are you and your client both in agreement that this plea hearing can be conducted by Zoom rather than him appearing in person?
Yes, Your Honor.
You're all right with that, Mr. Holt?
Yes, sir.
All right. Now, I'm going to hold up the first page of this document that's entitled Plea of Guilty with your case number, the name. It says you're pleading guilty to the indictment, count 1, which is the only count. You see that? You recognize that document?
Yes.
And on page 3, there's a line that reads, I enter this plea voluntarily. Right below that appears to be a signature of Chris Holt and 10/23/24. And I'll hold that up there. And is that your signature and the date you signed that document?
Yes, Your Honor.
And where were you when you signed it with your attorney?
In Ms. Barber's office.
All right. And When you signed this document, did you understand as an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing?
Yes,
And do you feel you had enough time to fully consider the matter?
I have.
And it's been a week or a little over a week, almost two, since you signed it. So have you changed your mind, or is this still what you want to do?
Still want to do.
And you're going forward voluntarily?
Yes.
All right. The agreement states you're going to plead guilty to the charge, a fifth-degree felony, that you understand that carries a possible prison term between 6 and 12 months and a fine of $2,500, a possible license suspension of 6 months to 5 years. Now, are you facing any felony charges anywhere else?
No, sir.
And are you currently on probation, community control, parole, or post-release control?
On probation here?
For another case besides this one?
Yes.
Okay. And what is that for? Can somebody tell me?
It was for a misdemeanor driving charge.
A what?
He's also on PRC, Your Honor.
Oh, okay. And the probation you're on, is that out of this court or a different court?
I believe it's county court.
Okay, so that's a misdemeanor, not a felony.
Yeah.
Okay. I'm only interested in felonies. And the prosecutor just indicated that you are also on PRC. I'm looking to see, yeah, here's the notice of that. It's actually filed with, I think, yeah, right after the indictment. And it says that you have, according to this, 117 days remaining under your PRC. That was dated back in September the 10th, so that would be down to about 47 days, something like that. The reason to bring that up is under the law, if you're convicted of committing a new offense while under PRC and you're sentenced to prison, the court could also sentence you for committing that offense while you're on PRC to an additional period of 1 year, whatever time is left, whichever is greater. In this case, the 1 year is greater because you only got about 40, 50 days. So that would be served consecutively if you went to prison. Do you understand that?
I do.
All right. Now, on this case...
Your Honor, if I may, he's also on community control out of this court for felony 5 possession.
Oh, okay. All right. Well, if you plead guilty then to this charge, that could be, would be, I should say, a violation of your community control in your other case, which means that could be, if you were sentenced to prison on this case, that would also result in the revocation of your community control in that case. You could be sentenced to a term of imprisonment consecutive to this charge. You understand that?
Yes, sir.
Okay. So I think that's an F5, so that means the total could be 24 months. You understand that?
Yes,
plus
sir.
1 year on the PRC. All right. Now, I'm not required to sentence you. Oh, let me back up. In this case, PRC is not mandatory. It's permissive or optional. So if you were put on PRC, it would be for a period of between or up to a period of 2 years. And if during that period of time the probation department felt that you weren't complying, they would file a written notice of the court. You would get a copy. There'd be a hearing. You'd be entitled to have an attorney. And if the outcome of that hearing was you failed to comply, then at that time the court could revoke your community control and then sentence you to prison and fine you the $2,500. And again, if you were revoked because you committed a new felony, then again, any sentence imposed on that case could be ordered to be served consecutively to this one. You understand that?
Yes, sir.
All right. Now, the charge alleges in this case that on or about April 18, 2024 in this county, you knowingly obtained, possessed, or used Schedule II controlled substance to methamphetamine. So that's the charge with the penalties I've described for you. You understand what it is you're charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
You understand the possible penalties?
I do.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, possible outcomes of a trial with your attorney?
I have, sir.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to get you to plead guilty?
No.
On page 2, there are a couple of lines that are printed in bold and underlined that read, defendant will enter a plea of guilty to the indictment, state defense jointly recommend community control, residential abuse treatment, substance abuse treatment, and a referral to drug court. Has anyone promised you anything other than that to get you to plead guilty?
No, sir.
And under the law, the matter of sentence is up to the judge. And so even though there's a recommendation you get community control, and also that you be considered for drug court. Neither of those are binding on the court. You understand that?
I understand.
All right. And I believe I do see an application for the drug court, so you've already filed that. All right. Now, you have constitution. Well, first of all, do you hold any excuse me, license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
Now, you have certain rights you must understand before I can accept this plea. You do have a right to have an attorney, and I appointed Ms. Barger to represent you. That wasn't simply to work the case out, but to provide any defense that could be available under the law that you'd like her to provide. So, if you decide that you don't want to do this, that you would rather defend against the charge, she'll continue to represent you and defend you, including a trial, if that is what you want. You understand that?
Yes, sir.
Under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence will be presented. They'd be instructed on the law, and then that jury of 12 would decide by unanimous verdict, meaning they'd all have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means to give up in writing your right to have a jury trial. In that case, you would have what's called a court trial, meaning the judge would be the one who would hear the evidence instead of a jury, apply the law, and decide whether or not the state proved your guilt. You understand that?
Sir.
All right, now you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means, witnesses against you have to come into court and testify in front of you, your attorney, and anyone else may be present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
I do.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court will issue a court order, it's called a subpoena, and would force those witnesses to come to court, be available to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
I do, Your Honor.
Under the Constitution, Mr. Holt, you have privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you by anyone at any time in the proceedings. And in fact, no one can even talk about it in the proceedings with one exception. If there is a jury trial and you do not testify, then the judge instructs the jury that because it is your right, they cannot consider it for any purpose at all. Do you understand that?
I do, Your Honor.
Under the Constitution, Mr. Holt, you are presumed innocent of this charge till proven guilty by the state of Ohio on every essential element of the offense charged by proof beyond a reasonable doubt. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been indicted. In fact, under the law, you don't have to present any evidence at trial. You may, but you are not required to. So whether you do or not, the burden stays on the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
I do, sir.
Right now, you're originally entered a plea of not guilty. Not guilty plea denied the allegation, and the indictment denied you committed any crime. If you change your plea from not guilty to guilty, that's the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits the crime, that you committed the crime. And that plea waives gives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. Well, with that exception, your plea of guilty would waive or give up your right to a jury or court trial, waives or gives up your right to confront witnesses against you in open court and cross-examine them through your attorney, waives or gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives or gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case, with a couple of exceptions, one of which is if you are sentenced to the maximum sentence, you can file an appeal. And there are other limited circumstances, but any appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
I do, sir.
And are you a U.S. citizen?
I am.
Now, do you have any questions about the charge of the possible penalty?
No, sir.
You understand it?
I do.
You understand the plea agreement?
I do, sir.
And again, you understand the recommendation of sentencing is not binding on the court?
I do.
Do you have any questions about the Constitutional rights I've explained?
No, sir.
You understand those?
I do.
You understand what the guilty plea means, what will happen if you enter that plea here today?
I do, sir.
Now, do you have any questions you'd like to ask your attorney or want to speak with her about anything before we go any further?
No, Your Honor.
Do you have any questions at all about anything I've gone over today?
No, sir.
All right, then is it your decision to go forward with this plea agreement, plead guilty voluntarily today to the charge in the indictment?
Yes, sir.
All right, and as to the charge then, it alleges that on or about April 18, 2024 in Highland County, Ohio, that you did knowingly obtain, possess, or use a Schedule II controlled substance methamphetamine, a fifth-degree felony in violation of Section 2925.11 of the Ohio Revised Code, with the penalties I've described to you previously. How do you plead?
Guilty.
All right. Court finds on this day in open court, defendant was advised of all of his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to criminal Rule 11. The plea is accepted and order filed. Defendant is found guilty of count 1 of the indictment. The court will order that the matter be referred for a pre-sentence report that include assessment for substance use disorder and or mental health treatment. Sentencing hearing will be set for December the 11th at 9 a.m.
Your Honor,
Yes.
I have to be in the magistrate's courtroom at 9 a.m.
Well, not if you're here. Judge Trump,
True, but-
magistrate. So we'll take you first.
Okay,
Actually, we can do it at 8:30.
that'll work.
All right, 8:30. All right. See Officer Benson to make appointment for your PSI, and you've already filled out the drug court information. Now, I do note in a report here, you've been testing positive, and I see that you had been in treatment with a recovery counsel. I guess that was on an outpatient basis, but it would be in your best interest, Mr. Holt, if there's a recommendation for you to go into, I think it's going to be residential treatment since you've been engaged and have not completed, that it'd be in your best interest to go into that as soon as there's a bed available. Because number one, it shows me that you're serious about this, and that means I'm more comfortable with giving you community control. If you don't, you continue to use until it comes up for sentencing. That tells me you don't care. More likely for you to do time than to get community control. You understand?
Understand.
All right. So see Officer Benson on the way out. Thank you. All right. Do we have Mr. Huntsman there? All right, this is case number 24 CR 135, State of Ohio versus Chase Aaron Ray Huntsman. Are you Chase Aaron Ray Huntsman, appearing there from the probation department?
Yes, sir, Your Honor.
All right, this is a pretrial being conducted by Zoom. The defendant's appearing as indicated from the probation department. His attorney is Sarah Barger, appearing from her office. Appearing from the prosecutor's office is Assistant Prosecutor King. This is a first pretrial, final pretrial set for the 20th of this month, and December 19 is a trial date. Now, see that the prosecutor has provided discovery. Looks like the defense has as well. So does that finish discovery?
That's from the state.
Yes, Your Honor.
All right, and do you anticipate any pretrial motions, Ms. Barger?
No, Your Honor. My client actually completed his change of plea form yesterday afternoon.
Oh, okay. So you want to just go ahead and get that scheduled then later
Yes.
this week? All right. All right. Well, once we do this, you got your calendar there?
I do.
Let me get the calendar. We'll go ahead and get it set. Officer Benson, is Ms. Curtis and Ms. Eubanks there?
Yes, sir.
Okay. We'll do Ms. Curtis next. We need to get a plea on this, Mr. Huntsman.
Plea date?
Yeah, well, do we have time Friday?
Yeah, let's see, we have 3 bond reviews at 8:30. Oh, that one got canceled, so we have 9 o'clock.
All right, you want to do 9 o'clock, Ms. Barger? Does that work for you? Friday? This Friday?
This Friday, the 8th?
Uh-huh.
Yes.
All right. So, Mr. Huntsman, we'll do this plea on Friday at 9 a.m. And we'll go ahead and do it by Zoom. You just go back there to the probation department because you're going to have to make an appointment to see them anyway after we're done with this, so you'll be there already.
Okay.
So 9 a.m. on Friday the 8th. Okay?
Okay.
All right, thank you. All righty, Brandy Curtis then. All right, are you Brandy Ray Curtis appearing from the probation department by Zoom?
Yes.
All right, this is case number 22 CR 241 State of Ohio versus Brandy Ray Curtis. As indicated, this is a pretrial being conducted by Zoom. Curtis's attorney is Jacob Wagner, appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. Defendant charged with 1 count of illegal conveyance, a third-degree felony, and 1 count of possession of drugs, a first-degree misdemeanor. It's a final pretrial trial set for December 9. Looks like discovery was provided. So is discovery, I don't see anything from the defense. Did you file your compliance, Mr.?
Your Honor, prior to that being required, we struck a deal. She's doing the diversion program tomorrow, meeting with Mr. King.
Oh, okay.
Then once she completes that, then I'll come over to Miss Oyer and get a plea date, Your Honor.
All right, sounds good then. So you know about your appointment tomorrow, Miss Curtis?
Yes.
All right, make sure you're there and make arrangements with that. And then as soon as you guys get things worked out, we'll get a hearing set next week maybe to get you in. All right?
Okay.
Thank you.
Thank you.
All right, Stephanie Eubanks. All right, are you Stephanie Banks appearing there for probation?
Yes.
All right, this is case number 24 CR 115, State of Ohio versus Stephanie Eubanks. Ms. Eubanks is appearing from the probation department. This matter is being conducted by Zoom. Her attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. Been charged with illegal conveyance of weapons or prohibited items onto the grounds of a detention facility. Third-degree felony, possession of cocaine, and aggravated possession of methamphetamine. Fifth-degree felonies. This is the first pretrial. Final pretrial set for December 11. Trial date set for January 13. It says 24 in the assignment notice that I believe on my writing, but I'm sure it's noticed as the 25th or the 2025. I see the state's provided discovery, and Mr. Wagner, yours will be due by the final pretrial. Do you anticipate any pretrial motions?
Not at this point, sir.
And do you have a written plea offer from the state?
I do, Your Honor.
Is your client aware of it?
No, Stephanie has been calling my office. I've been trying to call her back. We're playing phone tag, so
Okay.
she's not got the good offer. Could I inquire of her real quick, Your Honor?
Go ahead.
Is your number 763-2092?
Yes.
Okay, 'cause it's just going to voicemail, not picking up. So I'll call you later today just to go over the offer with you.
If he doesn't get a hold of you today, you call him tomorrow, okay?
Okay.
All right, because you need to get in touch with him so you know what's going on in your case.
Okay.
All right, anything further from counsel?
No, Your Honor.
I'll call you in a minute.
Thank you.
Thank you.
They do not, they've not logged in, so let's call them and see what's going on. All right, are you Christopher A. Brigner?
Yes, sir.
All right, this is case number 24 CR 158, State of Ohio versus Christopher A. Brigner. Mr. Brigner, you were indicted by the grand jury yesterday, along with Alan Green, on a charge of aggravated trafficking in methamphetamine and aggravated possession of methamphetamine. First count's the aggravated trafficking, alleges that occurred on about June 17th of this year in this county. The two of you knowingly sold or offered to sell methamphetamine. And then count two alleges on about the same date you both knowingly possessed that substance. Count one, a fourth-degree felony, carries a possible term of prison of 6 to 18 months, a fine of $5,000. Count two is a fifth-degree felony, carries a possible prison term between 6 and 12 months, a fine of $2,500. Both carry license suspensions of 6 months to 5 years as a possibility. You're entitled to have an attorney. If you don't have the money to hire one, the court will appoint one for you. So you have filled out the financial disclosure form, and is this form correct?
To the best of my knowledge.
You're not employed?
No, sir.
When's the last time you worked?
Man, it's
Been a while, I guess, huh?
around April.
April, okay. All right. Well, the court will appoint Attorney Catherine Hapner to represent you and enter a plea of not guilty on your behalf. We'll set a bond review hearing for Friday morning, the 8th at 8:30 a.m. by Zoom. Your first pretrial will be set for November 20 at 1:00 p.m. Final pretrial will be December 11 at 1:00 p.m. and your trial date will be January 16. The 2025 at 8 a.m. Bond will be set in the amount of $5,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. You'll be required to pay a deposit for certain statutorily required fees of $171 before you're released. If you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You'll be required to report to them immediately upon release. And then after that, once a week for 4 weeks. And then after that, as they determine, undergo a random drug test they may order, provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. And if any treatment's indicated, you'll enroll in and follow that during a period of this case while it's pending. You'll be under house arrest at your residence, which is 277 Harry Saunter Road, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. You may also attend appointments with an attorney or probation officer in this or any other case. You can go to any kind of job training, educational programming, classes, college, etc., church services, and you can also go to any family holiday events, but you have to go directly to and from those places, and the probation needs to be notified in advance that you'll be doing that. If you fail to comply with the probation or with the bond order, then the court could revoke that and have you held till further order of the court. And we'll notify your attorney of her appointment and have the hearing then Friday morning. Do you have any questions?
Yeah, so how much is my bond?
$5,000.
So how much do I need?
I don't know. I'm not a bondsman. You'll have to talk to bondsman about that.
Yeah, I didn't.
I don't know. I don't deal with that world. I'm not going to tell you because I have no clue.
Okay.
All right. Anything else?
No, that's it.
All right. Thank you. All right, are you Alan R. Green?
Yes, sir.
All right, this is case number 24CR160, State of Ohio versus Alan R. Green. Mr. Green, you were indicted along with Mr. Brigner by the grand jury yesterday on 2 counts, aggravated trafficking and aggravated possession of methamphetamine. First count alleges on or about June 17, 2024 in this county, you and Mr. Green did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance. That's a 4th-degree felony, which if convicted carries a possible prison term between 6 and 18 months, a fine of $5,000, and a possible license suspension of 6 months to 5 years. Count 2 alleges on about the same date that you two knowingly possessed that methamphetamine. That's a 5th-degree felony, carry a possible term of incarceration of 6 to 12 months, a fine of $2,500, and a license suspension. You are entitled to have an attorney to represent you in this matter, and if you can't afford to hire one, the court will appoint one for you at no cost. And I believe you did fill out a financial disclosure form. Find it here. Okay, there it is. Everything on this form correct?
It should be.
Says you're making $120 a month. Is that what, part-time work of some sort?
That's how people out and stuff.
I'm sorry?
Just help people out, my girlfriend and stuff, and
Okay. All right, the court then will find that you're entitled to appointed counsel, appointed Attorney Jacob Wagner of Hillsborough to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. We will set your bond review hearing for Friday, this Friday at the 8th at 8:30 a.m. by Zoom. Your first pretrial will be November the 20th at 1:00 p.m. Your final pretrial will be December 18th at 1:00 p.m. And your final, or your trial date will be January the 9th, 2025 at 8 a.m. Your bond will be set in the amount of $5,000 plus your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. You'll be required to pay a deposit of $171 for certain statutorily required fees. If you make bond, you report to the probation department at 117 East Main Street immediately upon your release. You'll be under pretrial supervision, and you'll be required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, and employer, and you'll be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings, appointments with an attorney or probation officer in this or any other case, also attend any kind of job training, educational programming, schooling, church services, and family holiday events during the season. And you'll be required to notify the probation department in advance of those times, and you must go directly to and from those appointments. And if you fail to comply, then the court could order you to do community, or could revoke your bond and have you held till further order of the court. Also, Deputy, going back, I meant to set his pretrial, or his trial date on the same time as Mr. Brigner, so that'll be January 16 instead of January 9 will be his trial date.
Okay.
All right, you have any questions, Mr. Green?
No, sir.
All right, we'll notify your attorney of his appointment, and we'll have your hearing by Zoom Friday morning. Thank you.
Thank you. How much is $5,000.
$5,000. It'd be 10%.